May I please, Your Lordship?
Yes.
My Lord, allow me to mention hearing item number 16. Hearing item number 16. Fine. If 2 weeks' time may be allowed. Yes, 16.
2 weeks' time.
Yes, my Lord. And in the meantime, I'll file my reply.
Learned Counsel for the petitioner, Mr. Taka Kichu is present. Learned Counsel prays for listing the matter after 2 weeks. And in the meantime, prays that he may be allowed to file the affidavit in reply. So, prayer is allowed, list after 2 weeks.
And interim order.
PP, Ms. S. Mary is present, as well as Mr. Search for
Passer, sir.
respondent number 2.
Respondent number 2.
So, the interim order passed earlier shall continue till the next date.
Much obliged.
May I please, Lordship?
Yes.
My Lord, I beg to mention item number 20 of hearing list. My Lord, yet to receive instructions, so let this matter become after 3 weeks.
Instructions not received.
Yes,
22 matter.
yes.
Why?
My lord, here the petitioner is seeking for compensation actually. It's been, I think, 3 years since the filing of this rate petition.
Is this the case where the union was directed to file an affidavit?
Yes, my lord.
Yes. Because they said that they have already
Yes,
released
my lord.
the amount.
Yes, my Lord.
Yes.
19 crores, something that we have released, but it is upon the state respondents as well as petitioners. Whether he is received or not, that one is not the way of that, my Lord.
No, it will be better for you also if they say on affidavit that they have already released. Then the court can give a direction to the state respondents.
Okay, my lord.
Yes, ma'am.
Okay, my lord.
So let them file. But last chance, okay, fine.
My Lord,
3 weeks.
I have communicated to register post, but not receiving any instructions. So,
You send a reminder again.
my Lord, yes, I used to send a reminder also. Anyway,
So 3 weeks.
my Lord.
Learned CGC, Mr. Zetan Mili, who submits that he is yet to get instructions in the said matter and prays for 3 weeks' time. So, Learned Counsel for the petitioner, Mr. C. Kongyak is present. So, since this is a matter pertaining to 2022, so the matter is fixed after 3 weeks, giving a last opportunity to the government, to the Union of India to file the affidavit. So, list after 3 weeks. Yes.
Must please.
Obliged, my lord.
May I please, Your Ladyship? Your Ladyship, kindly allow me to mention item number 6, Your Ladyship. Your Ladyship, here I'm yet to file my affidavit in opposition. Kindly allow me 2 weeks' time to do so, Your Ladyship.
Learned Counsel for the respondent, sole respondent?
Yes, Your
Sole respondent, Mr. James Nimai, who prays for 2 weeks?
2 weeks' time.
2 weeks' time to file an affidavit in this present matter. So, Learned Counsel for the petitioner is present and has no objection. List after 2 weeks. Yes.
Much obliged.
May I please, Your Lordship? Lordship, I beg to mention hearing item 21. Lordship, on behalf of the Counsel for the petitioner. Lordship, the Counsel for the petitioner is indisposed, so if the matter can come up after 2 weeks.
Who is indisposed? Kedovi?
That's it only. Yes.
Learned Counsel, MS such and such, makes a mention on behalf of the Learned Counsel, Mr. Zasit Sule, who is stated to be indisposed today. Therefore, she accordingly prays for listing the matter when
2 weeks.
after 2 weeks. Who is appearing? Government Advocate. Learned Government Advocate, Ms. Inahuli is present. So list after 2 weeks. Yes.
May I please, Your Lordship? Your Lordship, I beg to mention hearing item 18 and 19. With the consent of the other parties, if this matter can be listed on after 2 weeks, Lordship.
After 2 weeks. These are also very old matters.
Lordship.
You are mentioning on behalf of?
NK Loikam, Lordship.
What about the other side?
Have taken the consent of the other parties, Lordship.
Learned Counsel, Mr. Such and such, who makes a mention on behalf of the leading counsel, Mr. N.K. Lukam, to list the matter after 2 weeks. So it is stated that the consent of the appellant has been obtained for the adjournment. Stop accordingly, list after 2 weeks for hearing. Yes.
Lordship, I have a similar prayer for item number 7, Lordship.
7.
Yes, Lordship. If this matter can come up on Monday, Lordship.
Learned counsels, research, make submission on behalf, you are mentioning on behalf of?
Lordship, be people.
On behalf of PP Paul, learned counsel for the respondents to list the matter when Monday?
Monday, Lordship.
On Monday, accordingly list on 24/11. Learned counsel for the petitioner, Ms. Kim Penny is present, not petitioner, appellant. Yes.
Obliged, Lordship.
For motion, item number 1.
May I please the Lordship? Lordship, this matter is for non-compliance of this Honorable Court order dated 26/06/2025. Lordship, the petitioner represented on 12/01/2023 to Principal Director, Directorate of School Education for grant of invalid pension and family pension of her dead husband. However, it was not considered. Being aggrieved, the petitioner filed WPC 111
What
of
was the direction in the
Direction, Lordship, may I kindly turn to Annexure 2, page
page 11?
number 11, para 10.
Consider the case of the petitioner and dispose of the representation submitted. Representation is not disposed of.
Dispose of, Lordship. Oh, no, Lordship.
The direction is only to dispose of the representation.
Oh, yes, Lordship.
So that is not done. Representation is not disposed.
Yes, Lordship.
The present application has been filed under section 11 and 12 of the Contempt of Courts Act 1971, read with Contempt of Courts under bracket Gauhati High Court, close bracket, Rules 1977, and Article 215 of the Constitution of India, alleging willful disobedience of this court's order dated 26/6/2025, passed in WPC 112/2025. So, General Counsel for the petitioner, Ms. Such and such, give your name. Stop. It is stated that the WPC 112/2025 was disposed of on 26/6/2025 with a direction to the respondent number 5, Principal Director, Directorate of School Education, Nagaland, Kohima, to consider the case of the petitioner and to dispose of the representation submitted by the petitioner on 12/1/2023 within a period of 3 months from the date of the order. Stop. It is submitted that the order, the direction of this court is not complied with till date. Hence the present petition. Stop. Para. Issue notice. I think you will have to refile it. The direction was to Principal Director, but you have not made Principal Director a party. Okay. See, para 10. More particularly, respondent number 5, Principal Director, Director of School Education. And in your application, you have only made okay, Principal Director. What about the other respondents?
Lordship, this Honorable Court has specifically directed to Principal
Only
Director.
5.
Yes.
Okay, what did I say last time? Issue notice, na? Issue notice on the respondent, returnable within 4 weeks. So, the petitioner shall take steps for service on the respondent by speed post document as well as usual process within 3 working days. List after 4
Lordship,
weeks.
kindly allowed us to serve through Dusty service also.
Okay, you say as well as Dusty. Speed post as well as Dusty. List after 4 weeks.
Much.
For motion, item number 3.
Lordship, these matters are similar.
Similar.
Yes, Lordship.
Direction also.
Yes, Lordship.
Okay, similar order. Only the WPC number will be WPC 111 of 2025, and order date also same.
Yes,
Order
Lordship.
date also 26/6/2025. Okay, so speed post document as well as Dusty, and thereafter to file an affidavit. 4 weeks.
Much
For
obliged.
motion, item number 4.
Yes, Your Lordship. Your Lordship, this condemned petition is from the WBC 207 by order dated 26/06/2025, Your Lordship. Here in this case, the petitioner was serving as a bus conductor, and in that case, this Honorable Court has given a clear direction to call out his name for district level verification within 4 months. However, the respondent has not complied to this Honorable Court order, Your Lordship.
To send the name of the petitioner for verification. Your name has not been sent.
Lordship.
What about the documents? Have you submitted your documents? for
Your Lordship, I have
verification?
submitted my representation, and this Honorable Court has given direction to call out my name for verification and also to serve a notice upon me to furnish my documents to the department.
Yes, that was not given.
No.
Heard Honourable Counsel for the petitioner, Mr. Jasaj. So the present application has been filed under Section 12 of the Content of Courts Act 1971, read with Article 215 of the Constitution of India, alleging willful non-compliance of the order dated 26/6/2025, passed in WPC 207/2024. So, Honourable Counsel for the petitioner submits that by order dated 26/6/2025 in WPC 207 of 2024, the respondents number 1, 2, 3, and 4 were directed to issue notice to the petitioner calling for his documents to be verified by the district level verification committee, and thereafter take up the process for regularization within 4 months from the date of the order. Stop. It is stated that the respondents are yet to take any steps in compliance of the direction of this court, and hence the present application has been filed. Stop. Para. Issue notice to the respondents number 1, 2, 3, and 4, returnable within 4 weeks. Stop. The petitioner shall take steps for service on the respondents by speed post document as well as usual process within 3 working days, list after 4 weeks.
Oblige, Your Lordship.
For admission, item number 5.
Please, Your Lordship.
Yes.
My Lord, we can dispose of this contempt petition today, if it is convenient to Your Lordship. Lordship, unlike the other normal contempt petition, where usually we file that for non-compliance, here, my Lord, the contention of the petitioner is that the direction of this Honorable Court was partially complied with. So in that view of the matter, Lordship, relying on the judgment of this Honorable Supreme Court in Gauri Shankar versus Sajal Chakrabarti, where it says that non-compliance, if partial compliance is also amounting to non-compliance, and direction was given. So basing on that, Lordship, I'm coming before this Honorable Court, and I will keep 3 grounds why the petitioners are claiming that it is partially complied with. Lordship, it's a contempt petition, so showing the records, I won't have much submission, but my Lord, thereafter, there were 2 rounds of litigation. Earlier, Lordship, WPC 98K of 2000. By a judgment dated 25/9/2000, the judgment was, direction was given. Thereafter, Lordship, WPC 185 of 2019, by the Lord, direction was given on 29/11/2022. That is how we are before this Honorable Court.
So we are now concerned with 185.
Yes, 185, but then Lordship will find that in 185, since it is interconnected, the learned single bench has also toiled on 198 keep the background. So that way, Lordship, I will be going through. Lordship, I will be relying upon specific paragraphs. I will be relying on paragraph 2 to 10, 14, 15, 17, 18, 23 onwards. So, Lordship, kindly allow me to page 64 is the judgment. My Lord, kindly allow me to read paragraph 2 to 10 so that Lordship will get the background about the earlier judgment, because the issues are all interrelated with compensation and verification. Lordship, paragraph 2, 230 petitioners have joined together and filed the instant writ petition challenging the actions of the respondent authorities, that is the state of Nagaland, for illegally dispossessing them from their pata land, and thereupon have also not paid any compensation in that regard. The brief facts of the case is that by an order dated 17/2/1995 issued by the ADC Dimapur, it was directed to all the villagers resident from Purana Bazar to Chumukutima to submit the details of their establishment, construction costs for rebuilding houses and other developments in their respective lands to the said office within a period of 1 month for acquisition compensation for the purpose of forelaning. It was also mentioned that filling which claim for compensation would not be entertained. Accordingly, all the landowners, including the petitioners or their predecessors in interest, Lordship, may kindly keep this in mind, the petitioners or their predecessors in interest submitted the details of their establishment. While the aforesaid process was going on, the Deputy Commissioner Dimapur, Nagaland had issued a notification that is 7/4/2000, whereby it was mentioned that in pursuance to the government letter dated 9/2/2000, notice was issued under the provisions of an eviction of person in authorized occupation of public land Act 1971. Upon this, persons whose building in construction fell within the 27 meters of the, that is, 13.5 meters on either side from the center of the road, that is NH 110 to 123 from Purana Bazar to Chumukutima. It was further directed that as per the notification to all the concerned individuals to show cause on or before 2/5/2000 as to why an order under subsection 1 of the Nagaland eviction persons of unauthorized public land 71 should not be passed against them for evicting them from the said land. The particular notification was published in the newspaper. Thereupon, various landowners, including the petitioners, had submitted a reply to the Deputy Commissioner stating inter alia that they were being issued land patas by the state government, and being landowners have been developing their premises from time to time. It was further mentioned that as they were pata holders, the question of them occupying the land as unauthorized do not arise. Further to that, it was stated that if the district administration required land of the landowners along the National 39, Highway 39 for public interest, the same can be taken by the district administration after paying due compensation for both the land and the construction developed therein, and landowners should not suffer due to contradiction within the government, that is, issuing pata on the one hand and urban planning on the other hand. As the apprehension of the landowners, including the petitioners, continued in spite of submitting the short cause reply, they constitute a union that is known as such and such and filed WPC 98K2000. The case of the petitioners therein, the said petition, that is 92K2000, was to quash and set aside the eviction orders and give a direction to the respondents to pay compensation. This court, by an order dated 6/6/2000, issued rule and an interim order that until further orders be stayed. Thereafter, the said petition, that in the 98K, was disposed of by judgment dated 25/9/2000. This court, while disposing the said petition, took into consideration that the initiation of proceedings under Nagaland eviction of person in authorized occupation was without jurisdiction and void ab initio, as the land in question did not fall within the exclusionary definition of public land. It further appears from the said judgment passed by this court that this court had categorically held that instead of initiating proceedings against eviction of persons Act 1971, the appropriate authority is obliged to initiate for acquisition of the land either by publication of public notices as envisaged under Section 4 of the Acquisition Act of 1984, any section under National Highway Act 1967, which is a peri materia of the procedure prescribed under the Land Acquisition Act 1894. In paragraph 10 of the said judgment, this court also observed that contention being made by the Learned Counsel for the state respondent that in the circumstances the petitioners were encroachers and did not have any rights to the land instead of preferring a civil suit, the state government would be a liberty to initiate proceedings under National Highway Act 1956, where adequate provisions have been provided. For deciding the, Lordship, I'm reading the judgment quoted. Despite paragraph 7 of the judgment, despite of the quashing of any impugned orders for the reasons stated above, one thing is clear in my mind, that the proposed acquisition of and is for important purpose, namely the expansion of National Highway 39 into 4 lanes, and I am of the view that instead of initiating proceedings under Unauthorized Occupation Act, the appropriate authority is obliged to initiate for acquisition of land either by publication of public notices as invested under Section 4 of the Act or any other such and such. Then Mr. Zimomi considered landowners are ready to part with your land situated within the vicinity of the proposed expansion of 4 lanes and of NH 39, provided your lands are acquired and compensation is paid to them. It is, however, contended by Mr. Jamir that on earlier occasion, the Deputy Commissioner Dimapur resorted to settle the dispute amicably by summoning the landowners to the spot on different dates with land documents and others. However, the landowners did not cooperate with the administration. This submission has been resisted by such and such that, in fact, the landowners assembled on the spot on the appointed day, but it is the administration who filled the turnip. Be that is as it may, I have already observed that the intention aimed at resolving the dispute without further delay. It is so, if so necessary, even by making amicable settlement of the market value of the land, and compensation be paid to the landowners by settling amicably instead of going through the elaborate procedure which would ultimately delay in acquisition of the land and payment of compensation. It is expected that when such notification is issued by the administration informing the landowners, they should cooperate with the administration and settle the matter amicably so the larger interests of the public do not suffer. Before parting with the record, I may dispose of one argument advanced by Jamir. It is contended that the landowners have been encroaching upon the landmark for the expansion of National Highway. If on this availability of documents and landowners found the same portion of the landmark for expansion of National Highway 39 is encroached upon, definitely the appropriate authority may file civil suit and evict the encroacher, and ultimately would linger the litigation that may create more problems than solving it. Alternately, the appropriate authority can resort to provisional National Highway 1956. Paragraph 7. The petitioner further alleged that instead of complying with the above judgment, notice dated 3/3/2001 was issued by the ESD Kohima restricting the construction development along the National Highway. The landowners thereafter being aggrieved submitted a representation dated 17/4/2001. The said representation was further supplemented by another representation dated 16/11/2002. Subsequently, White letter dated 8/1/2003 issued by the Revenue Officer, Office of the Deputy Commissioner, Dimapur District, Nagaland. The landowners were allowed to go ahead with the construction development work without disturbing the proposed 4-lane of National Highway. It has been further mentioned in the writ petition by a letter dated 3/5/2000 issued by Project Director National Highway at Gauhati. A direction was issued to the Revenue Officer Dimapur and Kohima, Nagaland for preparation of detailed project report for Dimapur to Kohima section of NH 39 and initiation of land acquisition proceeding for a proposed project. In the said letter, it was mentioned that fund will be available after submission valuation of the land and property as per the norms to the district administration. In the emergency executive meeting held on 23/5/2005, the committees decided to communicate about the rate of the land compensation and other related matters after holding proper discussion with concerned landowners only. Accordingly, a representation was submitted to the Deputy Commissioner. The said representation was forwarded as per verbal instruction of the Revenue Officer to intimate him the rate of land compensation to the affected landowners while widening the National Highway 39 to convert it into 4-laning. Subsequently, third of the Deputy Commissioner Kohima, Dimapur provide notification dated 10/6/2005, directing the general public, Pataholzer landowners from Purana Bazar to Chumukutima that no new construction, either permanent or temporary, including building sheds, fencing walls, would be allowed within 30 meters road, that is within 15 meters from the center of the road. It was further mentioned in the said notification that no compensation will be entertained in case of their non-compliance of the above notification. The Office of the EM Kohima Nagaland Highway had prepared and submitted a TBR for improvement of the city portion of Dimapur to such and such in September 2006 to the Minister of Shipping Transport, Government of India. Their work was therefore allotted to respondent number 9 sometimes in the month 2017. Subsequent thereto, the respondent number 9 started widening the road in construction in the month of November 2000. Indeed, in that process, private lands belonging to the petitioners in the stretch from Purana Bazar to Chumukutima was alleged to have been engroached by the respondent authorities. Then, Lordship, may kindly allow me to refer to paragraph 14. Page 74. It would therefore be seen from the perusal of the affidavit in opposition filed by the respondents that their specific stand is that the land concerned respondents have not encroached upon any private land, but have only exercised their right on the basis of the principle of right of way, which was 27 meters, that is 13.5 meters from center of the road on either side. The said affidavit in opposition reply to the said affidavit in opposition, an reply was filed denying the contents of the affidavit in opposition. It was mentioned that the present four-lane widening was constructed by encroaching upon the land of the petitioners in destruction of stunting properties without payment of compensation. It was mentioned that the construction was carried out outside the original right-of-way belonging to the national highway by encroaching the land of the petitioners in destruction of their properties. The actions of the respondents were in clear violation of the judgment in order dated 25/9/2000, passed in TPC 98K of 2000. Then, Lordship, kindly allow me to refer to paragraph 17 and 18. The matter came up before this court on 16/3/2022. This court, after hearing the matter at length, directed the concerned deputy respondent authority, as Deputy Commissioner Dimapur, to file an affidavit bringing on record the basis on which the government of Nagaland claims the right of way in respect of the road that has been and is 27 meters. The record further reveals that Deputy Commissioner Dimapur Nagaland had on 15/9/2022 filed an affidavit in compliance with the order dated 16/3/2022. The said affidavit is very pertinent in deciding the instant dispute. It has been mentioned that the Works in Housing Department, by a letter dated 10/2/1999, had directed the Deputy Commissioner Dimapur to issue notification reserving 30 meters of land width along the national highway. On the basis thereafter, notification dated 28/4/1999 was issued by the Deputy Commissioner notifying that 30 meters, which is kept as route reserve along National Highway 110 km to 123 km at Purana Bazar to Chumukutima Highway, and a copy was given to all the German GPs along the Purana Bazar to Chumukutima for information. Thereafter, the government of Nagaland, the Works in Housing and Roads, filed letter dated 9/2/2000, had written to the Deputy Commissioner on the assessment of the compensation, issue of notice for reservation of land from National Highway 39 110 to 120 km section. It was decided by government that no compensation will be paid for private buildings in other structures falling within the road reserve area. Further, the Deputy Commissioner was instructed to proceed for eviction against encroachers within the 27 meters road, that is 113.5 meters on either side from the center line, and to take possession of the same. It was mentioned that due process may also be undertaken to hand over 27 meters road, that is 13.5 meters on either side from the center line to the PRDF. So, my lord, there was no formal process. The Working Housing Department simply wrote a letter to the Deputy Commissioner Dimapur. Then the land was taken over, all the buildings, structures destroyed. That was the issue. Then, Lordship, may kindly allow me to read paragraph 23.
Ultimately, what did the court direct?
I'm coming to that, Lordship, just to give a background. Because, my lord, I would like, now paragraph 23, my lord, I would like to read at paragraph 81, few lines, 1, 2, 3, 4, 5, 6, 7 lines from the bottom, at page 81.
23.
Yes. I want, because, my lord, I would like to submit 3 grounds to appreciate that. I want to give a brief background. The learned senior counsel further submitted that some of the petitioners in the original proceedings, that is 98K/2000, are a part of the instant writ petition. Further to that, the other petitioners are successors in the interest of the original petitioners. He further reiterates that such and such. Then, Lordship, may kindly come to, now I'm coming to the findings, Lordship, from paragraph 27 onwards. My lord, from 27 to 34 are the findings which I would like to read, Lordship.
Yes.
This court also needs to take into account that in the state of Nagaland, all lands are not government lands. There are lands which are not cadastrally surveyed. These lands are private lands. In respect of such lands, government do not collect any revenue over such lands. However, transfer of such land takes place with the consent of the village council, and written records of such transfers are being maintained such as such. On the basis of such records made, then the village council issued a certificate acknowledging the rights of the purchasers. In the instant case, some of the lands fall within the cadastrally surveyed government lands, and some lands are private lands. The documents which have been included to the instant petition are documents where the petitioners had claimed their rights over respective lands on the basis of Pata periodic list provided, being issued by Deputy Commissioner with the approval of the government, or certificates being issued to the village council, commonly known as village patas. In the said backdrop, if this court take into consideration the submission made by learned additional AG to the effect that government is the owner of the land in question, and government has a right to reserve the land in the name of right of way. This submission, if allowed, in the opinion of this court, would amount to defeating the rights of the persons who have been vested with rights on the basis of issuance of patas, periodic lists by the government or the Deputy Commissioner, or the rights accrued to the person on the basis of patas being issued by village council. This court, while initially hearing the matter on 16/3/2022, inquired as to on what basis the respondent authorities has reserved 27 meters, that is 13.1 meters from the center of the road, and in that regard had directed the Deputy Commissioner Dimapur to file an affidavit. There is no material produced to show that the land reserved for a right-of-way in question was originally 27 meters, or there was any acquisition of the rights from the petitioners who were enjoying periodic list or rights acquired on the basis of the village council certificates. From the said affidavits, the details which have already been mentioned here in the above, it transpires that the Secretary to the Government of Nagaland Works and Housing Department has requested the Deputy Commissioner Dimapur to issue notification reserving 30 meters of land along its section of national highways as route reserve, and also take necessary action to hand over 27 meters width of this section to the project Siwak for undertaking the work. This communication was issued on 10/2/1999. Most surprisingly, the Deputy Commissioner, without following any due process, issued a notification on 28/4/1999, notifying for general information of the public landowners from Burana Bazar to Chumbukti Meda that 30 meters width of the road is hereby kept as route reserve along the national highway, 110/123 meters section of the highway, for four-laning of the portion of the highway. In doing so, the Deputy Commissioner have not taken into account the rights of the person, the landowners which vested on the basis of periodic list being issued or on basis of village council certificates being issued would be affected. No doubt, the appropriate government authority would have the power to acquire lands on account of public interest, but in doing so, if it affects the vested interest of the people, landowners, the same can only be done by following the procedures established under law. This aspect of the matters has been stipulated under Article 300, and Lordship, the judgment is referred. I'm skipping that. Then, my Lord, paragraph 30, I'll only read a little portion. Subsequent to that, in another judgment such and such, where the Supreme Court took up for consideration the question in the concerned facts as to whether the state has taken a process for acquisition and has followed the same in accordance with law. In paragraph 13, 14, 15, the Supreme Court has held that it is the burden of the state to prove that there has been any acquisition of land as well as payment of compensation in the said case. So burden of proof is for the state government. That is what I want to highlight. That is the finding. Then, Lordship, you kindly come to paragraph 31, page 90. In the backdrop of the above law laid on by the Supreme Court, and taking into consideration the facts involved wherein the state of Nagaland has failed to show any document that the road reserved for right-of-way was initially 27 meters, and is being specific in it being a specific case that by way of notification dated 28/4/1999, the road reserved for right-of-way was enlarged to 30 meters, and no materials produced to effect show that the road reserve was enlarged without acquiring the land. This court is of the opinion that respondent authorities, more particularly Deputy Commissioner Dimapur, could not have enlarged the right-of-way by reserving the existing road to 30 meters of width as road reserve along the national highway of the highway for four-laning without following the due procedures of the law. The action of the respondent authorities of reserving in the name of right-of-way without showing how the excess land was brought within their field of right-of-way therefore stands vitiated. This court, while taking the judgment, put a specific query upon the learned additional AG as well as the learned counsel for respondent number 2 as to whether you would like to retain the land. It has been submitted that four-laning road has already been constructed, and as such, the question of returning the land to the landowners, if any, was any transgression to their rights do not arise. Further, the additional AG also submitted that this court would not be in a position to decide as to what compensation, if any, has to be paid, taking into account that it would require a fact-finding as to whether the petitioners at all have any rights or if at all their rights have been affected. This court duly agrees with the said submission of this court that this court would not be in a position to decide as to whether the petitioners have any right over the lands or, for that matter, whether there has been transgression to their rights on accounts of reservation or widening of road to the 27 meters. This court have already observed that the Deputy Commissioner would not have enlarged the route without following the due process of law and without payment of compensation in the interest of justice, directs the concerned Deputy Commissioner to carry out the fact-finding inquiry. The learned additional AG has also drawn the attention of this court to the fact that the entire stretch of land, that is NH 39 from 110 to 123 section, falls within the domain of Deputy Commissioner Chumukitima as well as Deputy Commissioner Dimapur. Considering the above, this court therefore disposed of instant writ petition with the following observations and direction. 1. This court declares that the action of the Deputy Commissioner to enlarge the width of the road reserve, that is 27 meters, that width of the road reserve to 27 meters, that is 13.5 meters from either from the center in the stretch of National Highway from 110 to 123 kilometers of National Highway from Dimapur to Chumukitima without carrying out any acquisition, and more particularly the notification dated 28/4/1999, consequently stand restricted for not following the due process. The owners whose lands falls within 13.5 meters from the center of the road and the stretch of the road, if affected, would be entitled to compensation as mandated under law. My Lord, Lordship kept in mind that this is the suit land. This is the issue in dispute. 27 meters, 13.5 meters, either side of the road. Yes. So the issue is whether there is any finding or verification within this suit lane. That will be which I will be raising. 2. Taking into account that this court is not in a position to decide how much and which land of each of the petitioners or any of the landowners have been affected, it will require a fact-finding inquiry. This court directs the petitioners to submit their claims, including their claims or destruction of their properties, along with their land documents and other documents for verification before the Deputy Commissioner Dimapur, Deputy Commissioner Chumukitima, before whose jurisdiction their land falls within 45 days from the date of the instant order, taking into account that only 230 petitioners have filed the instant writ petition, and there may be other landowners who may have been affected. This court further directs the Deputy Commissioner Dimapur as well as Deputy Commissioner Chumukitima to issue a notice in the daily news of wide circulation calling for any claims along with their documents of verification. This should be done within 20 days from the date of instant order. 3. On the basis of the claims as well as the documents, Lordship, it is claims and documents. Lordship, you kindly take note that so submitted, the Deputy Commissioner Dimapur and Chumukitima or any other person to whom the Deputy Commissioner deems fit to entrust but not below the rank of ADC shall verify the said claims on the basis of the documents submitted within the period of 6 months from the date of submission of the claims by the persons interested. In filing the said claims, the petitioners as well as the landowners would be at liberty to also submit claims regarding their loss suffered on account of demolition of their properties. Upon verification, if it is found that petitioners or landowners have been affected on account of enlarging of the width of the national highway, that is 27 meters, 13.5 meters from the center of the road in the stretch of NH 39 from 110 to 123 kilometers section of the highway from Dimapur to Chumukitima, then in that case, the Deputy Commissioner Dimapur, Chumukitima, in consultation with the state, as well as the respondent number 2 shall initiate proceeding for acquisition under National Highway Act 1956 by following the due process. It is made clear that if in the circumstances the petitioners or the landowners are aggrieved by the fact-finding inquiry by the office of the Deputy Commissioner, the petitioners or the landowners would be at liberty to initiate proceedings under Code of Civil Procedures. 6. If the petitioners are aggrieved by the actions of the respondent authorities in respect to entitlement and quantum of compensation, the petitioners can avail the remedies available under the National Highway 1956. So, Lordship, that is the direction given. Now, my Lord, thereafter, Lordship, kindly allow me to refer to on which date how it was done. Now, my Lord, the affidavit filed by respondent number 7. My Lord, page, Lordship, sorry, before I go to there, Lordship may kindly allow me to, in my writ petition, Lordship, in my contempt petition, I'm sorry, petition, my Lord, page 100.
Yes.
Notice was issued on 22nd March 2023 by the Deputy Commissioner Dimapur for verification from Zion Hospital on 23/3/2023, second paragraph, for verification.
Okay.
Then, Lordship, the next two letters, 101 and 102, is the order issued by the Deputy Commissioner Chumukitima for verification. Then, my Lord, then thereafter the petitioner being not aggrieved with the report has submitted the representation in 103-104. Now, my Lord, I'm coming to the affidavit of respondent number 7. My Lord, page 11.
This is DC Dimapur.
DC Dimapur. Lordship, affidavit has been filed by DC Dimapur as well as DC Chumukitima. Kindly allow me to refer to the documents. My Lord, page 11 is the committee constituted. Then, my Lord, page 12 is the submission of compensation for damage of structures. Now, my Lord, Lordship may kindly come to page 25. I kindly allow me to read because I would. Submission of verification report, page 25, Lordship. Submission of verification report for claims received in connection with such and such. Sir, in pursuance of the order dated 15 March, the committee members, along with landowners, claimants, and office bearers, landowners, has jointly conducted verification of claim received from 23rd March to 26th. During spot verification of claims, the land of Sri T. Kapikoza, an area of 187 square feet, was found lesser than his land documents. The land documents furnished by Srimadi Ayanlawati and Srimadi such and such at Naharbari were not proper, as the land was mutated from Patam Bugri, rendering their claim inadmissible. Whereas all other claims was found to be equal or in excess of their land documents furnished. Lordship, we kindly appreciate this fact. Whereas all other document lands were found to be equal or in excess of their land documents. 7 cases of damage of structures were found. Accordingly, PWD Housing has prepared estimate fully approved by Chief Engineer amounting to rupees such and such. Estimate for land compensation for Mr. Such and such has not been prepared, included in the report, as the procedure for the same is beyond the purview of the committee. Then, Lordship, may kindly see next page. Again, on the next day. In pursuance of the such Gauhati High Court judgment such and such, dated 24, calling for claims for land damage and compensation within 40 days. Subsequently, a verification committee was constituted, headed by additional Deputy Commissioner to assist the Deputy Commissioner to verify the land claims received within the claim period, considering the following members. Meeting with the NH Landowners Union was held on 21st March 2023 to discuss and plan for carrying out the land verification. The committee conducted spot verification and claim received along with the claimants and office bearers of National Highway Owner Land Union between 23rd March to 30th March. During the initial course of verification, 15 claimants absented themselves despite information being given to them, and therefore a notice dated 24th March 2023 was issued to the NH 29 Landowner Union and published in a newspaper, and spot verification conducted on 27 March 2023. During spot verification, depending on the claims, land and properties were verified and accordingly assessed. A total of 35 claims were verified, and those claims found to be genuine are assessed. Remaining claimants abstained themselves from the verification of their claim despite giving notice to them through the NH Landowners Union and published in the newspapers. The detail of each claims are enclosed for land and damaged structures. Lordship, in Dimapur, in Jumukinima, unfortunately, due to lack of information, because Lordship landowners are a few hundreds, many of them are spread over the Nagaland. So they were not aware about the ongoing verification. They came to know later on. Thereafter, they have submitted representation to the Deputy Commissioners of Dimapur Jumukitima that they were absent and they were not aware, and the opportunity was not given to them, so they made a request. I will submit the representation submitted to them then, that they should be given an opportunity to verify. But that was denied till date. That is one of the ground I'm submitting, that at least opportunity should have been given to all those who could not avail who were absent because of unavoidable circumstances, because it was only published in the newspapers, and everyone does not read newspapers, so that is one ground I'm taking. Now, my lord, here, then Lordship Meghali said, page 27. My lord, pata numbers, areas, my lord, what has happened is, Lordship, before I refer the documents, kindly allow me to explain. What the verification team has done was, they invited all the landowners for verification. They were directed to submit your land patas. Everyone submitted your patas, village pata, government pata, whatever. What the verification team has done is, they simply measured the area in occupation, area allotted in their respective pata. They did not till date the 27 meters suit lane, 13.5 meters either side is yet to be verified and examined. How it was acquired by the government, and who is the landowner, that has not been examined till date. What the authority has done is, they simply called the patas from all the landowners. It was then the area specifically mentioned in the land pata was measured underground. And if it is less, then they recommended. If the occupation of the area in the pata is the land occupation specification provided in the pata is less than the actual on the ground, then they said it is less and it was recommended. If it is excess in the pata, excess occupation, it was not recommended. If it is same, then it was not considered at all. Only those persons in the pata which was found to be less were considered.
So you are aggrieved by the way the inquiry was conducted?
Exactly, and I will come to that point. Secondly, Lordship.
So isn't that a new cause of action? How can this court deal
No,
with
my lord, the point I'm making is, I'll leave it to your lordship, but I'm making my submission on this. Lordship, if you satisfy, lordship may kindly examine. The point is this, that for example, lordship, serial number 5, Mr. T. Koza copy found less on ground by 187 square feet. Lordship. Now, my lord, the issue is only about 13.5 feet either side of the road. The subject matter.
Yes.
Now, Lordship may kindly say at page 62. The meeting was chaired by Deputy Commissioner. The meeting was attended by such and such. In the meeting, the landlord was briefed about the land measurement found during the survey. A total of 187 square feet was found to be less than his pata area, for which the area was assessed and to be proposed for land compensation. Accordingly, during the meeting, the landlord requested for rupees 2,000. However, passing the land location valuation recent transaction, finally a final rate of 1,500 as only per square feet was fixed and agreed upon. A solatium of 15% under Section 11 shall also be added above the land compensation rate for payment. The point I'm making is, Lordship, that suit land is 27 feet, either side 13.5. If anybody is found to have, if government has found to have encroached the land of any person within that 13.5 either side of the road, compensation has to be paid within the suit land only. Now what the department has done is, for all those, here a person has been found less in occupation of 187 square feet. So for that, the whole land, which presently he is under occupation, government has decided to give compensation. Till date, the area to examine the 27 feet suit land. But a person, then another classic example, Lordship may kindly come to the affidavit in opposition of the Deputy Commissioner Jammu Kohima. My Lordship, the report of the Lordship, kindly allow me to refer to the page I have. Yes, Lordship. My Lord, page 197. Page 197 is the report submitted for land. Lordship, may kindly come to serial number 6, page 1999.
6, yes.
My Lord, page 19 is 1 Ruku Zotso. My Lord, less by 2,82,277, 2,82,775 square feet, less by 2, as per the village pata. I was informed that if this, now it is in his occupation. Direction was only to examine 13.5 feet either side of the road. Now the only report is excess, same, less. And for those person who is, the present occupation is less than the pata given, all is recommended. I'm told this gentleman, in the event of 150 rupees per square feet, he is entitled to get around 70 crores, if this recommendation goes. But the subject matter of the direction was 13.5. Lordship, may kindly read the first direction. The suit lane is 27 feet.
That's why I've understood.
Yes.
So only regarding that 27 feet they were supposed to verify.
Exactly.
But they have verified the entire pata land.
We have verified the entire pata land, and now people who are in less than the exact pata land from our copy Koza, Dimapur, he is getting for the whole pata, which is less. And Lordship may kindly appreciate the fact that those land, for example, this gentleman, 2,82,770 square feet, presently is in his occupation.
Okay, I understood, but then the direction of this court was only to verify.
My lord,
Fact finding,
the point-
verify.
yes.
In a contempt petition,
My
what
lord, the question is this.
direction can the court give?
The question is
That
this.
is the problem.
I'm coming to that. The question is, Lordship, the main issue is direction number 1 of the judgment.
That's right. That means they have not understood.
So, my lord,
the
that is the,
direction
so the
properly.
point I'm making is, my lord, the point I'm making is, the direction has not been fully complied with. They have not verified. They would have simply verified, Lordship, whether who is the landowner of that 13.5 meters either side of the road. Verification has to be, because government has considered that it was not, there is a finding by this honorable court that that 27 feet was acquired by the government without following through due procedures, and that acquisition was struck down.
That finding is already.
So, my lord, so direction of this honorable court was to the deputy commissioner to go on the ground and verify to whom this belongs. 27 feet, who is the...
In that 13.5 and 13.5.
Yes, to simply verify who is the owner of that land. And if at all there is a genuine landowner, consider those people for compensation. That was the direction. But what they have done is they have totally misunderstood the direction. And instead of that, they have verified the whole Pata land. And now some people who are in excess, who are less, for those people who are less than the Pata, they are recommended to pay compensation for the whole land, which has not been acquired by the government. For the land construction, road construction is only 27 feet. So, my lord, in that view of the matter, Lordship, my humble submission, and in view of this, Lordship may kindly take note of the fact that there was a detailed hearing of this case on 14/5/2024. Lordship may kindly see the order passed on 14/5/2024. This is not the first time the case is heard in detail, Lordship.
14/5/2025.
2024, Lordship.
Yes.
Lordship may kindly see,
Dependency shall not be a bar.
Lordship, what has happened is,
Verification.
Lordship may kindly allow me to refer to my affidavit in reply. I was directed to file an affidavit accordingly, through an affidavit. In affidavit in reply to paragraph 7, I have filed the record.
Filed on 11 June.
Lordship. Then Lordship may kindly see the annexure B. Page 7.
B.
My lord, this affidavit was, Lordship, affidavit in reply, Lordship, it was,
Yes. Letter dated 28 November.
yes, Lordship. To the Deputy Commissioner, Chumrikrima Dimapur, prayer for immediate re-verification in compliance with such and such. Referring to the subject cited above, I am directed to forward herewith a letter dated such and such from landowner union and request your good office to re-examine the verification and conduct re-verification on spot in consultation with the landowners union. In view of all these issues, Lordship, this was a direction given by the PW Works in Housing Department. Accordingly, Lordship, on 14/5/2024, I placed this paper document on record, and court passed an order, and I was directed to file this affidavit to place this document on record. However, my lord, in spite of this, they have not done any re-verification on the ground. And also, Lordship, my lord, I'm submitting a document, Lordship.
So,
My Lord, I have submitted a representation, my Lordship may kindly see that Lordship, it is not very legible, but then Lordship may kindly bear with me. Some people were out of station during when the verification was done. So, my Lord, he submitted a representation that, my Lord, we were out of station, so to give us an opportunity. My Lord, this will be a little more clear. Lordship, can you allow me to exchange this? I will give you a little more legible one. My Lord, the finding of the Deputy Commissioner was that, verification team was that, of the report was that some people could not were present. So, my Lord, I'm only giving one copy, but several people have submitted representation to Deputy Commissioners of both Dimapur and Chumukutima that look, unfortunately, we were not aware and our land were not verified, so kindly give us opportunity. But, my Lord, it was also refused. So at least those opportunities should have been. So taking all those into consideration, and the fact that Lordship, the suit lane is 27 feet, 13.5 either side of the road. Here, Lordship, the Deputy Commissioner Chumukudima is recommending compensation for a person 2 lakhs, more than 2 lakhs in the area. I was informed that by the current estimation, it may come around 70 crores. And he is wondering, because it is in his position. And, my Lord, he is also wondering what to do. So that is so some discrepancies are there. Some discrepancies. So, my Lord, if you want to go strictly as per your finding, I'm not which way the verification.
13.5, they have not verified.
No, Lordship, see, they are basing the claim on the basis of the land pata. So we have to verify the land pata. So if they are in excess occupation, Lordship, then there are encroachers. And if they are in less occupation, for that matter, we are going to pay compensation to them. So how can they claim that all the land belongs to them? No. From 13 meters to here, Lordship, see, they have to produce the documents. So the pata will show the area of the.
Suppose his land is this much. So
Yes.
from this much can be that 30, say for example,
Yes.
13.5. So they have to measure only this portion,
Yes,
not the whole thing.
that is the point. That
So
is
in order
that
to
is the direction,
understand-
Lordship.
In order to verify, they have to show the area as per the pata. So if we measure the area, most of them are in excess occupation of government land. Actually, so to say, we have to evict them also, or take action against them, Lordship.
Lordship, as per the judgment of this Honorable Court.
It's very clear, on the basis of the land
My Lord-
pata, we have to measure
My Lord-
whether we have encroached the land or not.
See,
The
thing
area
is-
mentioned in the pata, So when we verify, Lordship, most of them are in excess occupation of the pata.
See, the direction, the finding of this court. The deputy, in doing so, the deputy commissioner has not taken into account that the rights of the persons, landowners which stood vested would be affected. So the court held that this was done without any process, due process.
Exactly. That's what the court finds.
Yes.
So what is the direction of this court? The direction of this court is to
Could not have
conduct.
enlarged the right of way by reserving the such and such without following the due procedure of the law.
My Lord, that finding of this Honorable Court was relying the judgment of the Supreme Court. Burden of proof is on the state government. How it was acquired? That is what the judgment says.
Otherwise, my lord, if we read the direction is very clear, directing the DC, Dimapur, and Chumukidima to conduct a spoke verification. And if there is any encroachment, if there is any utilization of the land, then to pay compensation to the petitioner. The notice was widely published. After everything is completed. Now they are bringing one after another. Your Lordship, if at all they are aggrieved, this court has also given the opportunity to approach the civil court. If at all they are aggrieved.
Landowners whose land falls within that 13.5 meters, if affected, would be entitled to compensation.
Yes. So for that matter, they have to produce the land pata, and we have to verify whether we have utilized their land. In my affidavit, I have clearly stated.
My Lord, let me conclude.
Yes,
Then
yes.
let me conclude with my submission because I will not take much time now. So, my Lord, my submission is threefold. That the suit land, 27 feet, has not been, in spite of the clear directive, the respondent authorities are yet to verify the 27 feet suit land. You have to enter and verify the 27 feet suit land, and the burden of proof is for the respondents, government. Secondly, Lordship, unfortunately, some people were left out, so at least that opportunity should have been given to them when representation has been submitted. Thirdly, Lordship, as rightly pointed out by your Lordship, till date, my Lord, whether I am in excess or same or less, that have no meaning here because, my Lord, the direction was only to give a specific finding whether 13.5 meters has been encroached in a person's land and whether property has been destroyed and damaged there. Now, my Lord, in that view, my Lord, and then, Lordship, in that view of the matter, this Honorable Court, then we submitted representation and Works in the Housing Department given the direction to the Deputy Commissioner to go for re-verification. The letter is there. On the basis of that letter, Lordship, this Honorable Court asked for a detailed hearing on the other day. All these issues which we are discussing with you were repeated that the same day, and then this Honorable Court came to a finding that they should not be a bar, witnesses should not be a bar to go for verification, and accordingly, unfortunately, that also has not been done, so that may be taken into consideration. The direction of this Honorable Court was on 14/5/2024. Well, I'll conclude with a judgment. 2015, 8 ECC 165. My Lord, I'm reading from paragraph 16 onwards, 16 to 19. The learned senior counsel on behalf of the respondent has contended that there are neither any pleadings nor any specific prayer in the writ petition filed by the complainants nor any specific directions were given in the judgment or orders of both the High Court as well as this Court to the respondents in regularized the services of the complainants with effect from 1981. The said contention cannot be accepted by this Court for reason that it is contrary to the Court and therefore the same is fully untenable in law. The purport of the judgment in orders of the High Court as well as this Court makes it amply clear that respondents shall regularize the service of the complainants with effect from 1981 in the post of junior engineer. However, in our considered view, the reliance placed upon the judgments in orders of the High Court as well as this Court does not support the contention of the complainants for the reason that there is willful disobedience on the part of the respondents as they have partially fulfilled the direction given by this Court as well as the High Court with regard to regularization of the services of the complainants from the year 1987. However, further direction is issued to the respondents to regularize the services of the complainants from the date of their initial appointment as junior engineers, that is from the year 1981, not complying with the directions issued by this Court from the above mentioned year would amount to deprivation of the legitimate rights of the complainant as determined by the High Court and this Court in the judgment in orders. After taking the litigation, in their litigation pleading documents on record and rival legal contention urged on behalf of the parties into consideration, we direct the respondents to comply with the above aforesaid directions. After properly understanding the purport of the judgments in orders of the High Court as well as this Court, for this aforesaid reason, we give one more opportunity to the respondents to comply with the judgments in order in toto for the regularization of the services of the complainants from the year 1981. The same cannot be treated as a fresh direction issued in the contempt petitions to the respondents as we have indicated the purport of the operative portion of the judgment in order of the High Court as well as this Court. The respondents shall comply with the order as indicated above and submit their compliance report within 4 weeks from today. So, my Lord, my respectful submission is that it is within the prerogative of this Honorable Court, since judgment direction has been, the purport of the judgment has not been fully understood, My humble prayer is to give a direction to fully comply with the direction of this honorable court in the light of its directions. Much obliged, Lordship. It's a contempt petition. I have very less to say, just to point out the record.
May please, Lordship, Lordship, as your Lordship has already gone through the direction, I don't need to read again, but I'll rely on my affidavit, Lordship, of affidavit respondent number 7. My Lord, may kindly come to page 2, paragraph 4. Page 2, paragraph 4. Yes. That with regard to the statement made in paragraph 2 of the petition, the same is admitted as is pertaining to the extract of the direction of this Honorable Court and order dated 29/11/2022. The direction 2 of the judgment and order dated 29/11/2022 at paragraph 34 inter alia should be read as, taking into account this court is not in a position to decide how much and which land of each of the petitioners or any of the landowner have been affected. It would require a fact-finding inquiry. This portion of the judgment is germane to the issue under consideration, as the Honorable Court was not in a position to decide how much and which land of the landowners had been affected and had therefore for a fact-finding inquiry. In Dimapur district context, which is a cadastral survey area, the fact-finding inquiry involved A. Submission of Jamabandi Pata by the landowners. B. Scrutiny verification of land or other related documents by comparing the same with the Chitha Jamabandi book, which is maintained by the record branch. C. Spot verification based on the area mentioned in the land document to determine the actual damage caused. And D. Computation of land and structural damages compensation, if any. Paragraph 5. That with regard to the statement made in paragraph 3 and 4 of the petition, the deponent begs to state that the present comment would be confined only to those averment that has been directed towards the office of the Deputy Commissioner Dimapur. That this Honorable Court by judgment and order dated 29/11/22 passed in WPC 185 of 19 had issued various directions. At para 34.2 of the SIC order, this court has explicitly held that, taking into account that this court is not in a position to decide how much and which land of each of the petitioner or any of the landowners have been affected, it would require a fact-finding inquiry. This court directs the petitioner to submit the claims, including the claims for destruction of the properties, along with their land documents and other documents for verification before the Deputy Commissioner Dimapur and or Deputy Commissioner Chumukedima, before whose jurisdiction the land falls within 45 days from the date of the instant order. Accordingly, notice was published on 23/12/2022. Petitioner documents Annexure B1 to the contempt petition, as directed by this court at Direction 3 of Para 34 to the judgment and order dated 29/11/22. The then Deputy Commissioner, vide order number such and such, dated 15/3/23, constituted a committee headed by the Additional Deputy Commissioner Dimapur as convener to verify the claims of land damage compensation under its jurisdiction. All the documents submitted by the National Highway 29 landowners as regard land ownership were verified, and accordingly, vide order dated 22/3/23, the then Deputy Commissioner Dimapur fixing the date for spot verification from 23/3/2023 onward, still completion of all claims falling from Purana Bazar to Daroga Pathar under Dimapur district. The committee members, along with landowners, claimant, and office bearers of National Highway 29 Landowners Union, conducted the spot verification from 23/3/23 to 30/3/23. During the spot verification, land and properties were verified and assessed accordingly. Consequent thereto, the PWD Housing Government of Nagaland was entrusted to prepare the detailed estimate for damage of structure, and by vide order dated 28/4/23 and 1/8/23 submitted its report estimate to the answering respondent office. Thereafter, the ADC Headquarter Convener Verification Committee, vide letter dated 5/8/23, submitted its verification report along with the assessment for payment of compensation in respect of land and structural damage. Since the answering deponent was not the competent and final authority to sanction the payment for the said compensation, the then Deputy Commissioner, via letter dated 5/8/23, having verified each claim, received by the committee a proposal for land and structural damage compensation amounting to 78,35,545 only was submitted to the Commissioner Nagaland. It is to be noted that the competent authority to make such sanction lies with the stake-level acquisition authority. Therefore, the claim of the respondents that the Deputy Commissioner had totally misunderstood and misconceived the direction of this Honorable Court passed in WPC 185/2019 and only verified the land and property presently occupied by the petitioner landowner in the undisputed area is totally misconceived and misrepresented. To this end, it is reiterated that at Direction 2, Para 34 of the judgment and order dated 29/11/22, this court was not in a position to decide how much and which land of the petitioner had been affected and had therefore directed the answering respondent office to make a fact-finding inquiry. Further, at Direction 3, Para 34, this Honorable Court had directed that on the basis of the claim as well as the documents so submitted, the Deputy Commissioner Dimapur and any person to whom the Deputy Commissioner deemed fit to entrust but not below the rank of ADC shall verify the said claims on the basis of the documents submitted. Thus, on submission of the patas by the petitioner landowners, spot verification based on the area mentioned in the respective patas was conducted to determine how much of the land had been affected due to the construction of the foreland from Purana Bazar to Chumukedima. Thereafter, keeping in consonance with Direction 4, Para 34, the operative part reads upon. Upon verification, if it is found that the petitioner or landowners have been affected on account of enlarging the width of National Highway 39 from 110 km to 123 km section of the highway from Dimapur to Chumukedima, then in that case, the DC Dimapur and DC Chumukedima, in consultation with the State of Nagaland as well as the respondent number 2, shall initiate proceeding for acquisition under National Highway Act 1986 by following due process. It was ascertained that out of 36 claimants, Lordship, it's very important to note this. It was ascertained that out of 36 claimants, only 6 landowners, so only 6 of the petitioners who are affected, Lordship, were found to have been affected on account of expansion of the national highways. Be it noted that the Pentecostal Mission Church, KVH Chopi, Hoshipu, Ke Vishipu, SPY To Zimomi, Rumpung Rangko Zilian had only claimed for compensation in respect of structural damages, while D. Kape Koza, petitioner number 25, claimed for land compensation. Be it further noted that 1. 17 landowners, viz. Petitioner number 20, 21, 23, 25, 27, 28, 31, 145, 170, 171, 193, 194, 200, and 4 others were found to be in excess occupation. That is, even though they were occupying more area than what is mentioned in the land patas, their land did not fall within the foreland. 2. 11 landowners, viz. Petitioner number 30, 33, 191, 182, 183, and 6 others were found that the present occupation tallied with the area mentioned in the respective patas and that the land did not fall within the foreland. 3. 2 landowners, viz. Petitioner 188 and 190, claim were rejected due to the land documents not being proper, as it was found that the land has been mutated from Padam Pukri. Thus, no compensation for land or structural damage was determined in respect of the 30 landowners. On the other hand, 6 landowners whose land were affected due to widening of the National Highway 29 foreland were duly assessed by the competent authority, and the same has been forwarded to the Commissioner Office. Further, the claim of the petitioners that the respondent authorities had reduced the size of the plot of land in the land records, and then when new pata were issued from time to time, the respondent authority had reduced the size of petitioner's land in view of the unauthorized extension of the highway is totally false, misconceived, fabricated, and an abuse of the process of court. Apart from ambiguous allegation, no other documentary or contrary evidence has been produced for the same. Per contra, the Jamabandi submitted by the landowners and the record of right boot makes no mention that such reduction in the area of the land has been done by the answering respondent office. 6. That with regard to the statement made in paragraph 5 of the petitioner, it is reiterated that all direction issued by this Honorable Court via judgment and order dated 29/11/22 has been duly complied with. 7. That with regard to the statement made in paragraph 6 of the petitioner, It is stated that the statement that the respondents are yet to complete the verification of the land affected on account of enlarging the width of National Highway 29 is totally false and hence denied. As stated in the preceding paragraph, the then Deputy Commissioner, via letter dated 5/8/23, had submitted the verification report along with a proposal for land structural damage compensation to the Commissioner, Nagaland. Further, while computing the land compensation, the petitioner number 25 was personally present at the meeting held on 4/8/23 and a rate of rupees 1,500 per square feet was agreed upon by him. Therefore, there is no willful violation of the court directive and no contempt of court has been committed by the deponent. As regards the other contention, the answering respondent is yet to initiate proceeding under the National Highway Act 1956. It is stated that this Honorable Court, at Direction 4, Para 34 of the judgment and order dated 29/11/22, had explicitly held that upon verification, if the petitioners or landowners had been affected, then the Deputy Commissioner Dimapur and Ochumukedima, in consultation with the State of Nagaland as well as respondent number 2, the Ministry of Transport and Highway, shall initiate proceeding for acquisition under the National Highway Act 1956. However, at the cost of repetition, it is stated that during the spot verification, the petitioners were found not to be affected due to the road cutting expansion of the National Highway 29. Therefore, the question of initiating proceeding for acquisition under the National Highway Act 1956 does not arise. Further, the Honorable Court at Direction 5, Para 34, had given liberty to the petitioners to approach the civil court if the landowners were aggrieved by the fact-finding inquiry. Therefore, if the landowners were aggrieved, they ought to have approached the civil court and not this Honorable Court by way of contempt petition. And, Lordship, again come to respondent number 8 affidavit.
Same grounds?
Same grounds, but here, Lordship, may come to page 4. Page 4.
Page 4.
Yes, I will read this paragraph further, the last paragraph.
Yes.
Just below, in the line of this bold letter, it is pertinent to mention, has your Lordship got it?
It is pertinent to mention.
Yes, it is pertinent to mention here that as in the context of Chumukedima district, as it covered cadastral area and non-cadastral area, all parties were informed through print media. As such, all such owners who were not in the list of petitioners were also informed, and accordingly, it was surveyed. Hence, final assessment is duly made. Further, the claim of the petitioners that the respondent authorities had reduced the size of the plot of land in the land records, and that when new patas were issued from time to time, the respondent authority had reduced the size of petitioner land in view of the unauthorized extension of the highway is totally false, misconceived, fabricated, and abuse of the process of court. Apart from ambiguous allegation, no other documentary or contrary evidence has been produced for the same. Per contra, the Jamabandi submitted by the landowners and the record of right boot, no objection from the village authority makes no mention that such reduction in the area of the land has been done by the answering respondent office. As per the spot verification report, 1. Most claimants are in excess occupation of land from what is mentioned in the land pata. 2. Some claimants are in lesser occupation of land from what is mentioned in the land pata. 3. Some claimants are in occupation of land tallied from what is mentioned in the land pata. Thereafter, the DC White letter dated 3/10/23 has submitted estimate assessment of compensation for damage of building structure amounting to such and such in respect of Ikaranigaon to Chumukedima under Chumukedima District 1, rupees such and such in respect of Ikaranigaon to Chumukedima under Chumukedima District 2, and rupees such and such in respect of Ikaranigaon to Chumukedima under Chumukedima District. So, Lordship, we have done the spot verification as directed by this court, and accordingly, we have submitted for compensation for those whose land are affected in view of the widening of the national highway. So, Your Lordship, we have to see what is the direction past this court and whether the respondent authority has complied. Is there any willful violation on the part of the respondent? Lordship has seen that there is no willful violation of this honorable court Lordship. And if at all the petitioner are aggrieved, this is not
They're
the
also
right.
not alleging that,
Yes.
they're saying that it's not fully complied with.
No, Your Lordship, we have to see that
their
this is a
allegation.
contempt. This is a contempt. So the contempt has to be confined only to what is the direction passed by this court. Lordship, I may be allowed to refer on 2004 ACC 400. 2004 ACC 400. Paragraph 7. Para 7. We may reiterate that the weapon of contempt is not to be used in abundance or misuse. Normally, it cannot be used for execution of the decree or implementation of an order for which alternative remedy in law is provided for. Discretion given to the court is to be exercised for maintenance of the court's dignity and majesty of law. Further, an aggrieved party has no right to insist that the court should exercise such jurisdiction as contempt is between a contemner and the court. It is true that in the present case, the High Court has kept the matter pending and has ordered that it should be heard along with the first appeal. But at the same time, it is to be noticed that under the coercion of contempt proceeding, appellants cannot be directed to pay the compensation amount which they are disputing by asserting that claimants were not the owner of the property in question, and that degree was obtained by suppressing the material fact and by fraud. Even presuming that the claimants are entitled to recover the amount of compensation as awarded by the trial court, as no stay order is granted by the High Court, at the most they are entitled to recover the same by executing the said award, wherein the state can or may contend that the award is a nullity. In such a situation as there was no willful or deliberate disobedience of the court, the initiation of contempt proceeding was wholly unjustified. So petitioner has other remedy, Lordship. So contempt is not the right forum. Then Lordship, 1999, 7 ACC 569. 1999, 7 ACC 569, para 9. Para 9. For holding the respondents to have committed contempt, civil contempt at that, it has to be shown that there has been willful disobedience of the judgment or order of the court. Power to punish for contempt is to be resorted to when there is clear violation of the court's order. Since notice of contempt and punishment for contempt is of far-reaching consequence, this power should be invoked only when a clear case of willful disobedience of the court order has been made out. Whether disobedience is willful in a particular case depends on the facts and circumstances of that case. Then, Lordship, 2010 ACC 285. 2010 ACC 285. (2010) 2010 ACC.
2010 ACC.
Oh. Yeah. Lordship, sorry, I have given the wrong citation here, but I'll read.
okay,
Yes,
just read it.
and I'll give. Para 4 and 5. 2010 ACC 285. Para 4 and 5. This court in the repetition has issued a direction for the consideration of the respondent representation by the state government. This direction was carried out by the state government, which has considered and thereafter rejected the representation on merits. Instead of challenging that order in a fresh writ petition under Article 226, the respondent took recourse to contempt proceeding which did not tie, as the order had already been complied with by the state government, which had considered their representation and rejected it on merits. 5. For the reasons stated above, the appeal is allowed. The impugned judgment of the High Court dated such and such is set aside, and the contempt proceeding petition filed by the respondent is dismissed. So, would you like?
Okay, just give the copy.
So, Lordship, no contempt has been made out. So, my prayer is that the petition should be dismissed. And the contempt is between the contemptor and the court, and the petitioner cannot insist this court that this court should pass another direction for re-verification. If at all they are aggrieved, they can approach any forum, Lordship.
Well, I forgot to point out one document in the affidavit of respondent number 7, Lordship. Sorry for the drop. I'm so sorry. Paragraph 31, page 31, page 30 onwards. The mutation records. Page 30, annexure 6 of the affidavit of respondent number 6. In respondent number 7, I'm sorry, Lordship.
Annexure 6.
Annexure 6, Lordship. These are the mutation records. What has happened is, Lordship, over the years, the property has changed hands. So accordingly, when the new seal date has been issued, the mutation record, it was mutated and it was handed over to a fresh landowners. Now what has happened is, I also know some record personally, as some people has bought the land before the whitening and mutation done thereafter. So over the years, when the mutation, as the road keep on enlarging and he started changing hands, in the mutated pata, the land measurement keep on reducing. Just for that purpose. In fact, they have annexed it.
But what can this court do? in
No,
such a
I'm only
situation?
pointing out the facts to you, Lordship, because it is my duty to point it out to
These are-
Lordship.
yes.
I'm only pointing out.
Records, Pata records the measurement and
Yes,
all that.
I'm only pointing out, Lordship. Much obliged, Lordship.
Learned counsel for the petitioner, Learned senior counsel, Mr. Takamasa, assisted by Mr. Sakilo. Also heard Ms. V. Shukri for the respondent number 7.
Six is.
I'm for 3 to 8, 3 to 9.
3 to 9, and Mr. Nangami for respondent number 1. Petition is disposed. I'll pass the order in the chair.
Okay.
Much obliged.
For admission, item number 8.
Kosa, this one, just into the chamber and then
May I please, Your Lordship?
give me the copies. 11 portion, 2 copies, 10 copies. Yes.
Your Lordship, I am informed that the IA is out of station, and that's why I could not able to get the CD also. So he will be back only by 9th December. So, Your Lordship, if the matter can come up on 11th or 10th.
He'll be back only on
On
9 December.
9th,
Okay, then.
so 11,
11 December.
yes.
Learned counsel for the petitioner, Mr. Muad Jami is present. Stop. Learned PP, Ms. Livika submits that the investigating officer of the case is out of station
Yes, Your
and will return only on 9th of December. And accordingly, it is prayed that the matter may be listed on 11/12/2025.
There's an interim note.
Yes. Accordingly, list on 11/12/2025, on which date the learned public prosecutor shall produce the updated scanned copy of the case diary. Stop. Till the next returnable date, the interim order passed on 6/11/2025 shall be extended. Yes.
Much obliged. Your Lordship.
For admission, item number 9.
Have you received the case record? No case record. Because this is charge sheeted already, isn't it?
Yes,
yes.
Learned counsel for the petitioner, Mr. Alam Wapang is present. Learned PP, Ms. S. Mary is present. By order dated 10/11/2025, this court had called for the scanned copies of the trial court records from the Court of Learned Special Judge NDPS Kohima. Stop. However, the same has not been received. The registry is directed to issue a reminder to the Learned Special Judge NDPS Kohima Nagaland to transmit the scanned copies of the trial court records. List on today's 25th.
Madam, can it be tomorrow? No. Because it's near, since it is near.
No, within 1 week they could not send it. How can they send in 1 day?
Okay. Then,
At least 1 week should be given. 24th.
okay.
At least on 24/11. Because we have to see the bail granted to the other co-accused also.
It's, Madam, an annexed that order.
You may have an X, but then the original case report has to be seen.
Thank you.
For orders, item number 10.
I please, Your Lordship. As per office note, service upon respondent 1, 2, and 6 is still awaited.
2 and 6.
Yes, 1, 2, and 6. So,
Trial court record has come.
not
We
yet.
had called for the records also. That is also noted. Okay, learned counsel for the petitioner, Ms. Sajjan is present. Stop. The office note dated 13/11/2025 indicates that service report in respect of respondent number 1, 2,
Two
and 6 is still awaited. Stop. The trial court records from the Court of Civil Judge Senior Division, Dimapur, is also yet to be received. Stop. Accordingly, list after 3 weeks on a date to be fixed by the registry. Stop. In the meantime, the registry shall also issue a reminder to the trial court, issue a reminder to the Civil Judge Senior Division, Dimapur, to transmit the scanned copies of the trial court records. This after 3 weeks.
Lordship, there is an interim.
The interim order passed earlier shall continue till the next.
For orders, item number 11.
May I please, Your Lordship?
Yes.
Your Lordship, in respect of respondent number 3 and 5, we have already filed our Valatnama as well as affidavit, and the same has been filed. However, Your Lordship, in the court record, it has not, the Valatnama has not been founded. And with this effect, Your Lordship, in the last order dated 9/10/25, Your Lordship. If I may take my Lordship to page number 4, Your Lordship. To the 4th paragraph, Your Lordship. If I may. This court has also noticed that affidavit has been filed by the respondent number 5, stating that the same is on behalf of both the respondent number 3 and 5. The court would only accept the said affidavit to be an affidavit on behalf of the respondent number 5 and not on behalf of the respondent number 3, since in a contempt jurisdiction, each of the respondents are required to file their individual response to the allegations made in the contempt. Therefore, we allow a period of 3 weeks' time to the respondent number 3 to file his response to the contempt petitions. And also, Your Lordship, continuation, Your Lordship, list this matter again on so-and-so with a report of service of notice on the respondent number 1, 2, and 4. No order is called for with regard to service of notice on the respondent number 3, since the respondent number 3 and 4 has already stated in his affidavit that he has been authorized by the respondent number 3 to file the affidavit, and therefore it can be presumed that the respondent number 3 has notice on these contempt proceedings, Your Lordship. And with this effect, Your Lordship, I filed a Valatnama on behalf of respondent number 3 and 5. Your Lordship, however, there was a corrections in the ghost title. Instead of COB, they have mentioned as a COND. And because of this, through the register, it got rejected, Your Lordship. So with this leave of this honorable court, if this Valatnama could be allowed, Your Lordship.
You file a fresh one then, isn't it?
Yes, Your Lordship.
Fresh Valatnama.
Yes, Your Lordship. However, the register got, however, I was got rejected on the register because of the ghost title, Your Lordship.
No, that's why you file a fresh one with
Yes,
a
Your Lordship.
corrected ghost title.
Yes, Your
isn't
Lordship.
it?
Lordship,
Yes.
what has happened was, earlier to this order, Your Lordship has passed an order directing the respondents to appear in person. At that point of time, the council was representing all the respondents. He said that his Mr. Yang was
Yes, Your Lordship.
senior colleague. Then on this day, on this 9/10, he made submissions that he will be representing only respondent number 3 and 5. And he had filed a combined affidavit, which the court has only accepted on behalf of respondent number 5. And they have filed their affidavit on behalf of respondent number 3. I get only this morning. I have received this morning. Therefore, I was directed to take fresh steps upon respondent number 1, 2, and 4. Thereafter, I have taken steps through registry as well as personal steps also I have taken. So,
For 1, 2, and 4.
1, 2, and 4. And in the order second last paragraph, I was given liberty to file the, before this court, the postal tracking of the inland speed post document issued on the respondent number 1, 2, and 4. Lordship, I was on the impression that I have already filed, but I have not filed yet.
It is not there.
Yes,
And
I have not
There is
filed.
an affidavit here on behalf of 3 and 5.
Yes, Your
So
Lordship.
you have filed for 3 and 5.
3 and 5, Your Lordship.
So I may be given
So
also.
the only discrepancy is regarding the
Regarding the
Vakalat
Vakalat Nama, Your Lordship.
They filed the affidavit without filing the Vakalat
Without
number.
filing the Vakalat
So
number.
court has,
Actually, Your Lordship, on the first place, I filed both of Vakalat Nama as well as affidavit. However, in the
I
record,
understand, but there was a mistake.
Yes, Your Lord.
Learned Counsel, Mr. A. Jamir, appears for the petitioner, and Learned Counsel, Mr. Your name,
Xinjiang Pong for Yang Water, Your Lordship.
appears for the respondents number 3 and 5.
3 and 5, Your Lord.
Learned Counsel for the petitioner submits that he was allowed to take fresh steps on the respondent number 1, 2, and 4, and to file an affidavit regarding the service of notice. Stop. However, he is yet to file the same and has therefore prayed for how much time?
1 week, I'll file
1 week's
within.
time to file the affidavit. Stop. Para. In the meantime, the Learned Counsel, Mr. C. Pong, submitting on behalf of the respondent 3 and 5, submits that the Vakalat Nama had been filed earlier. However, there was some discrepancy regarding the title,
Title,
regarding
Your
the
Lordship.
title of the case, and therefore it was rejected. It is therefore prayed that he may be allowed to file a corrected fresh Vakalat Nama for respondent number, on behalf of respondent number 3 and 5. Stop. Prayer is allowed. The
Your
same-
Lordship, in this case, I may be given 2 weeks' time, Your Lordship.
the same
Matter may be
may-
listed after 2 weeks.
may be
3
filed
weeks, Your Lordship.
Within 2 weeks. Stop. List the matter after 3 weeks.
Obliged.
Your Lord.
For orders, item number 12.
May I please, Your Lordship? Lordship, I made a mention in the last occasion regarding filing of my affidavit. Because I've been impleaded as a party respondent in this criminal petition, Lordship, as CAG, Comptroller and Auditor General. Now the police case has been registered, investigated on the basis of my report. That's how I've been made a party. Now, Lordship, as far as my role is concerned, I have constitutional obligations, Lordship. Lordship, I have made a mention in paragraph.
In the last order, it says you have sent the.
Yes,
for
yes,
vetting.
yes. I've already filed. Yes,
Oh, it's already filed.
filed, Your Lordship. I've served a copy upon the parties also.
So all the parties are represented now.
Lordship.
The other respondents.
Respondent number 8 is still awaited, Lordship.
Service report on respondent number 8. Who is respondent 8?
Miss Rosemary,
The private respondent,
private respondent.
the complainant.
Okay. Learned Counsel for the petitioner, Mr. Simon is present. Stop. Learned Counsel, Mr. N. Muzui, appearing for respondent number 7, submits that he has already filed the affidavit on behalf of respondent number 7. Stop. Learned PP, Ms. Mary is present. Stop. The office note dated 13/11/2025 indicates that the service report in respect of respondent number 8 is still awaited. Stop. You want to take fresh steps or will wait?
Lordship, if a fixed date may be given, since the leading counsel is from outside Nagaland.
Okay.
So
List
December
No, but
8th.
if
Okay.
the service is still incomplete, then we will list after 3 weeks, awaiting completion of service report in respect of respondent number 8.
In fact, the respondent number 8 is the main respondent.
main respondent,
But they have
complainant.
made him a performer. And I've been made the main party.
Complainant should be the main respondent.
Main respondent, yes.
Lordship, there's an interim, Lordship.
The interim order passed away shall continue till the next.
For
Oblige,
orders,
Lordship.
item number 13.
Oblige, Your Lordship.
May I please, Your Lordship? Lordship would like to place the compliance report. Yes. The direction of the High Court to give the minimum scale of pay has been granted, Your Lordship.
Have you given a copy?
Yes, they have also received.
You close it.
I have gone through the order which was furnished to me, Lordship. It appears like before approaching this Honorable Court, I was paid a scale of pay in terms of 1999 ROP. Now the government is granting the revised 2015. On perusal of the records furnished, I'm now being paid lesser than the earlier salary. So if I may be allowed to get instruction from my client. Because before approaching the court, I was paid 6,300. Now as per the revised ROP 2015, I'm getting only 6,050 in terms of the instruction, Lordship.
What was the direction?
To pay in terms of the...
To consider the petitioner's case for granting scale of pay.
In terms of the OM.
2015.
In terms of the OM 5/3/2025. So, Lordship,
So even in the order, it says ROP 2015.
Yes.
So, Lordship, accordingly, we have complied.
Yes, accordingly it has been done.
I just want to find out whether he has been paid the latest ROP, because the effective date is from the month of April. So if he's getting the from
tomorrow.
April, okay, on Thursday. Lordship.
Learned counsel for the petitioner, Mr. Mohan Jamir. Stop. Learned counsel V. Shukri appears for the respondents
Number
1 and 2.
No, Your Lordship, I'm for
Respondent
one.
number 2, Mr. K. Angami for
N.
respondent. Oh, N. Angami. I always get mixed up between K and N. K. Angami appears, N. Angami appears for respondent number 1 and Mr. M. Nongkamer for respondent number 3. Stop. The counsels for the respondents have produced a letter dated 31st October 2025, by which it is stated that the direction of this court has been complied with. So, however, the counsel for the petitioner submits that he would like to get some instructions from the petitioner and accordingly prays for listing the matter on Thursday, 20. Accordingly list the matter on 2011.
Oblige.
For orders, item number 14.
None appears for the petitioner when the matter is called list after a week.
For orders, item number 15.
Yes, what is this? Amendment.
Yes, amendment for prayer in the petition criminal, Your Lordship.
May I please, Your Lordship?
Yes.
Your Lordship, I'm mentioning on behalf of Yang Gauhati. Your Lordship, I pray that if this could come up in the presence of my senior, Your Lordship, because we have some objection to be placed regarding this.
But if you have objection, you file written objections also, not just verbal. You have to file written objection. Learned counsel for the petitioner, Ms. Such and such present. Stop. Learned counsel C.
Form, Your Lordship.
Mentioning on behalf of Mr. Yang Gauhati, learned CGC, prays for listing the matter when? After 1 week?
3 weeks, Your Lordship.
After 3 weeks, as he would like to file an objection in the present case. So accordingly, list the matter after 3 weeks, and in the meantime, the counsel for the respondent shall file their objection if so advised.
Obliged, Your Lordship.
For hearing, item number 17.
May I please, Your Lordship?
Yes.
Uh, This criminal petition is filed challenging for quashing the FIR dated 16/8/2024, Lordship, which is filed by the respondent number 2. Am I hearing?
Yes.
The annexer 1, at least FIR will be at
Dated 13/6/25. Scanned copies.
Lordship, FIR will be found at page number 13, Lordship.
Which?
13, 13. 13. Lordship, I read the FIR. With due respect and humble submission, the undersigned would like to approach your concerned authority to kindly register a case against Sri Birju Bora, such and such, for fraud, deceit, and criminal breach of trust. That Sri Birju Bora had taken a loan from me on the year 2021, a sum of rupees 5 lakhs, only on the 8th day of June, and as per the agreement, it was set forth that he would repay the said amount within 3 years from the date of execution of this agreement. There is the agreement, Lordship, between the parties. That after expiry of the period, as set out in the agreement, I have approached him several times through verbal and telephonic calls to repay the said amount. However, till date, Sri Birju Bora has not complied to my request, nor has made any effort till date to repay the said amount. That I have even approached him personally at his home town recently, but he would not comply to my request. Even ever since then, he has constrained himself from any possible connection from us, thus ignoring our calls and requests to repay the said amount. It is therefore the intervention of your incumbent office is necessary, as I have exhausted all possible means to recover the said amount. I therefore request your concerned office to kindly take note of this complaint and register a book, register and book the above mentioned person according to appropriate sanction of law and deliver justice. Lordship, on the basis of this affair, case was registered at Dimapur East Police Station as case number 137/2024 under section 318 within bracket 4 and 316 within bracket subsection 2 of BNS, Lordship, 2024. Lordship, my contention is that this is a purely civil nature case, Lordship. Police cannot take cognizance of this, Lordship.
Notice on the complainant is complete.
Pardon, Lordship?
Notice on the complainant is complete.
Yes, Lordship.
It.
Now, Lordship, turn to page number
1 minute, okay.
24, Lordship, loan agreement.
1 minute, let me just see whether the notice is insert.
Lordship. Dusty service was taken, Lordship.
Okay, 13, 13, okay, page.
Page 24, Lordship, loan agreement.
24, yes.
Lordship, loan agreement is, I have no objection with this loan agreement. This is admitted fact that we have a loan agreement, and I took financial help from the respondent number 2. Actually, Lordship, what even respondent number 2 is my maternal aunt. I took help for my business, and Lordship, I took financial help. Thereafter, what happened, Lordship? The lockdown came. I go through the tremendous loss in my business, Lordship. Then, Lordship, what happened? My maternal aunt's husband is a police officer, Lordship, of that. So, taking the advantage of this, she tried to pressurize me on various occasions to return the money. And Lordship, I have returned almost 2,35,000 till date, Lordship. Lordship may turn to page number
Where is that?
30, Lordship. These are the bank statement.
Yes.
Lordship, Lordship, fifth from the last, Lordship, on 6/8/2021.
6/8/2021.
Yes, Lordship. Transfer to Sanjay Mes. Sanjay Mes is the husband of this respondent number 2, Lordship. I have returned 5,000. Then, Lordship, come to the next page, 31. Lordship,
Page
8 line from the top, Lordship, on 7/8/2021, I have again returned 5,000.
Yes.
Then, Lordship, 32, page number. On 7th line, Lordship, 5/4/2022. Again, I have paid, Lordship, rupees 5,000. Then, Lordship, come to the page number 33. On 9th row, Lordship, 10 July 2023. Again, I have transferred 5,000, Lordship. Then, Lordship, page number 34. At 5th row, Lordship, 25th July 2023. I have transferred 50,000. For Bijli. Bijli means, Lordship, respondent number 2. And on 11th, in the 11th row, Lordship, on 34 page number, your Lordship will find I have returned 20,000. Then, Lordship, come to the page number 35. On 3rd row, Lordship, 31st July 2023, I have transferred 30,000. Lordship, thereafter, I have
So altogether, you have paid how much?
2,35,000 till date, Lordship.
2,35,000.
35,000 till date, Lordship, I have returned. So from this, Lordship, my intention was not to cheat the person, Lordship. This is because of the financial constraints. I could not return the money within the time as per the agreement, Lordship. So these sections are totally not attractive, Lordship. Not attractive. In this case, Lordship, I rely upon judgment 2014-1 GLT 887. I think that is on the record. Photocopy. Lordship, paragraph 7. Paragraph 7, Lordship, page number 889.
Yes.
Section 415 IPC, which defines cheating, reads as follows. 400 is cheating. Whoever by deceiving any person fraudulently or dishonestly induces the person so deceived to deliver any property to any person or to consent that any person shall retain any property or intentionally induces the person so deceived to do or omit to do anything which he would not do or omit if he were not so deceived, and which act or omission causes or is likely to cause damage or harm to that person in body, mind, reputation, and property is said to be cheat, Lordship. Next para, Lordship. It follows that an offense of cheating cannot be made out unless the following ingredients are satisfied. Number one, deception of a person either by making a false or misleading representation or by other action or omission. In this case, there is no such ingredients. I am trying to repay all the money. I have given at least 2,35,000 till date, or maybe more, Lordship. Number two, fraudulently or dishonestly inducing any person to deliver any property or to consent that any person shall retain any property, or finally intentionally inducing that person to do or omit to do anything which he would not do or omit. Paragraph 9, Lordship. It will also be appropriate to reproduce section 420 IPC for ready reference in order to appreciate the contention of learned counsel for the parties. The section reads thus: 420, cheating and dishonestly inducing delivery of property. Whoever cheats and thereby dishonestly induces the person deceived to deliver any property to any person, or to make, alter, or destroy the whole or any part of a valuable security or anything which is signed or sealed, and which is capable of being converted into a valuable security, shall be punished with imprisonment or either description for a term which may extend to 7 years, and such. Lordship, then Lordship may come to the paragraph 15, Lordship. It is clearly covered, Lordship, in this. It is now time to advert to complaint petition. It appears from the complaint petition that the petitioner and the complainant had shared a friendly relationship for a long time. The petitioner was in need of rupees 8 lakhs and he requested the complainant to give him a loan for the said amount. Because of the friendship and bona fide need, the complainant advanced a loan to the petitioner on the understanding that loan will repay on or before 12/3/2010, and in token of the assurance or promise, the petitioner also issued one check of rupees 8 lakh. The complainant had deposited the check after such and such, and the same came to be dishonored for insufficiency of fund. The complainant again made the petitioner with a request to refund back the said loan, though the understanding when the loan was advanced was that the loan was required to be repaid on or before such and such. Complainant agreed to accept rupees 50,000 only per month on installment basis till the entire loan money was liquidated. And to that effect, an agreement dated such and such was also executed. A sum of rupees 50,000 was also paid by the petitioner on the date of execution of the said agreement. The averments made in the complaint gives a clear picture that complainant was aware of the financial predicament of the petitioner and to help his friend in need. He had advanced a loan of rupees 8 lakhs. Even after the check was dishonored, he wanted to give some more breathing time to petitioner by agreeing to accept 50,000 per month towards the repayment of the loan. It appears that the petitioner did not harbor any apprehension that the complainant will not pay the amount, and also perhaps explains why he had not initiated proceeding under negotiable instrument and why he had agreed for repayment of the loan amount on installment rupees 50,000 per month. As such, no averment or allegation in the complaint was made that there was any fraudulent or dishonest intention on the part of the petitioner at the time of taking this one. Then Lordship come to paragraph 17. From the averments made in the complaint petition and the initial deposition of the complainant, where the complainant is only says that accused did not repay the loan as per promise made despite his many requests, and as the accused finally refused to repay the loan, he had filed the complaint. It appears to me that the dispute between the parties is purely of civil nature, arising out of breach of contract. Subsequent refusal to pay the balance amount does not satisfy the ingredients of cheating in as much as dishonest intention at the time of initial transaction is lacking. An offense of cheating would be constituted when the accused had fraudulent or dishonest intention at the time of making promise or representation. The complaint petition is conspicuously silent. So, in this case also, when the agreement was made, there was no such intention, and the petitioner trying his best to return the money So, Lordship, my humble submission that in this FIR also, there's no such ingredients, only taking the advantage of her husband, Lordship. This case was registered. So there is no such intention at the time of making the agreement, Lordship. And during this period, Lordship, the police many times, all the petitioner pressurize him because respondent number two, whose husband is a police officer, Lordship.
Yes.
Please, Your
There was
Ladyship.
even an agreement between them.
There was an agreement.
There was an agreement.
Yes, Your Lordship. But then
So
the
it appears
conduct.
that there was no deception or fraudulent in that using that.
Your Ladyship, regarding the disputed question of facts and intention, that will be tested at the time of evidence and trial. Your Ladyship, I would like to take Your Ladyship to the charge sheet, the third para, the criminal ingredient. That is reflective of deception and dishonesty. During the third para, during the course of investigation, the complainant, Bijili Mich, was thoroughly examined, and she stated that she is acquainted with Birju through his wife, Ritu Changmai, who is her cousin sister. She stated that Birju Bora had taken a loan of 5 lakh only on the 8th of June 2021, and that as per the agreement, the full amount was to be repaid within 3 years from the date of execution of a monetary agreement, that is 24/6/21. However, on expiry of the 3 years period, she approached Birju Barua several times through verbal telephonic calls and also in person to repay the said amount. However, he does not cooperate with her request. She stated that the accused, instead of paying back her money, has started to threaten her and has stopped responding to her calls. She further stated that her daughter is undergoing treatment for a rare medical condition and that she is in urgent need of the money. However, all her efforts have been in vain, therefore seeking justice with the help of the police. Here, your Ladyship, after the registration of the FIR, only a partial amount was paid. So that is also reflective of deception. Now coming to the...
No, Lordship.
No,
From
they cannot say that it's...
From 2021, he is trying his best to return the money. This is
The facts goes beyond that, a mere civil dispute. Your Ladyship may kindly come to the second page, the first paragraph of the second page. During the course of investigation, it was ascertained by analysis of CDR and LBS of mobile numbers and so that the accused Birju Boria was residing in Morantown, Dibrugarh, Assam. Accordingly, movement order was granted by the Commissioner of Police, Dimapur, for self along with 2 other personnel to travel to Morantown, Dibrugarh, Assam, and cause arrest of the accused person. On 29/8/24, we reported at Moran Police Station, Dibrugarh, and along with local police, we went to the residence to Birju Bora. Upon reaching the place, arrest was resisted by the family, and as we were distracted by his wife, Ritu Changmai's dramatics, Birju Bora absconded from the place. Efforts have been made to trace him through CDR and LBS. However, he could not be traced as his mobile was switched off and inactive. So this is, Your Lordship, absconding during investigation is also another ground, Your Ladyship. And on 12/9/24, information was received from the public prosecutor of High Court Kohima that Birju Bora has been granted anticipatory bail from the High Court and that he has been instructed to report before the IO within 15 days with effect from 17/9/24 for recording of statement. Accordingly, on 7/10/24, the accused Birju Bura, along with his counsel, reported at ESPS. Immediately, he was taken to District Hospital Dimapur for medical examination, and he was formally arrested. However, he was released on bail bond on the strength of the 3 hours anticipatory bail. So, Your Lordship, without the intervention of the police, Your Lordship, the petitioner is not in the, will not be years. So that itself, the conduct of the accused itself, is reflective of deception and dishonest intention. So, Your Ladyship, the intention of the accused to deceive is born out from his conduct, borrowing money on a promise, evading repayment for years, absconding during investigation, and making partial payment after the registration of the FIR. These facts goes beyond a mere civil disputes. And Your Ladyship, my prayer is that prosecution should proceed.
Lordship, that means the money transaction cannot be changed into a criminal breach of trust. Lordship. Here they can in the agreement also at page number 26, Lordship. Para number 4 of the agreement, Lordship. The last part, first party, all last third line, Lordship. First party all have every right to file any complaints money issued before any competent authority, Lordship, or before the court of law. So they can approach civil court also. They specifically mentioned about money issue. Lordship, taking the help of this, respondent number 2's husband, they have filed that FIR, Lordship, lost the FIR.
Sir, learning counsel for the petitioner, Mr. G. Sharma.
Yes, Lordship.
G. Sharma. Stop. Please, for the
Also for the petitioner.
Not for respondent, no?
No.
The case of the petitioner is that an FIR has been lodged by the complainant/respondent number 2 on of the FIR on 16/8/2024, alleging that the petitioner had taken a loan from him or her. Complainant, male or female?
Female.
That the petitioner had taken a loan from him for a sum of ₹5 lakhs. And an agreement was also signed. An agreement was also entered into between the parties. Dated 23rd June 2021, wherein it was agreed that the borrower/petitioner shall pay the amount, shall repay the amount within a period of 3 years, isn't it?
Yes, Lordship, within 3 years.
With the condition that the borrower shall repay an amount of ₹25,000. Shall repay an amount of 25,000 monthly. Stop. The FIR also states that after the expiry of the period as set out in the agreement, the complainant approached the petitioner several times to repay the said amount. However, the petitioner had not complied with the request nor has made any efforts to repay the said amount. Stop. It was stated that she even approached him personally at his hometown. However, he has constrained himself from any possible connection from the complainant and was ignoring her calls and requests to repay the said amount. In view of the same, the FIR was lodged and the case was registered at the Dimapur East PS, being case number
0137 oblique
10137 2024 under section 318 clause 4 316 clause 2 of the BNS. The learned counsel for the petitioner submits that the complainant is the maternal aunt of the petitioner and they have a very close relationship, and due to the relationship between the parties, the amount of these 5 lakhs had been loaned to the petitioner. So, it is also stated that after the commencement of the agreement, the petitioner started to return the said amount in installments as per the terms of the agreement, and he has returned an amount of rupees 2,35,000 till date. The copies of the bank statements have been annexed in the petition as Annexure 5 series. So, General counsel for the petitioner also states that the case is purely civil in nature, as there is an agreement between the parties that in case of failing to repay the borrowed money, the respondent number 2 may file money suit or complaint before competent authority. However, the respondent number 2 / complainant has approached the police in order to harass the petitioner. So, it is further submitted that in the facts and circumstances as stated above, there is no element of criminal nature in the present case, and the case has been wrongly registered against the petitioner. Learned counsel has relied on the case of Ram Jyoti Bhuyan, PRAMJYOTI, PHUYN, Jyoti Bhuyan was the son and reported in 2014 1 GLT 887. Referring to the above judgment, the Learned counsel submits that in the present case, that in the aforementioned case, the court had held that an offence of cheating cannot be made out unless the following ingredients are satisfied. Yes, we just reproduce this paragraph. Relying on the above judgment, learned counsel submits that even in the present case, there is no ingredient of deception or making false or misleading representation. And there is no ingredient, further, there is no ingredient of fraudulent or dishonest, fraudulently or dishonestly inducing the complainant to lend the said amount of rupees 5 lakhs. It is also stated that there is no ingredient of cheating or dishonest dishonestly inducing delivery of property in order to satisfy the ingredients of section 318 clause 4 slash 316 clause 2 of the BMS. Learned Council also submits that the complainant in the FIR has only stated that the accused slash petitioner has not repaid the loan as per the promise made. And therefore, subsequent refusal to pay the balance amount does not satisfy the ingredients of cheating, inasmuch as dishonest intention at the time of initial transaction is lacking. An offense of cheating would be constituted only when the accused had fraudulently or dishonestly made promise or representation at the time of the transaction. There is no, there is no statement between the FIR that the petitioner had dishonest or fraudulent intention at the time of the loan. In view of the actions the place that petition will be allowed and the proceedings of the GR case number 423/2024 will be rushed.
Much obliged.
You just sent it to the chamber.